We're discussing salary disparities. Many workers complain about receiving lower salaries than others doing the same job. Now, former Brand SA employee, that's Phumeza Qeza, we spoke to her yesterday, says this is her reality. She's taking the matter to the CCMA after being dismissed. Well, let's find out what the law says about this from Labour lawyer Sandile July. Mr. July, good morning and thank you very much for your time. You know, when I came across the story, I could see how many would easily feel that the employee is being targeted for challenging the pay disparities. But when you bring the law in as your guide in interpreting the conduct, you might arrive at a very different conclusion. I mean, here we have a situation where the injustice which she discovered, right, is not being dealt with first, but rather how she came to acquire the confidential documents. Just talk to us, or talk us through the legal intricacies of such a case insofar as access to documentation that is confidential.
You'll appreciate that I don't have the facts of this case, but based on what you are telling me, information that is confidential, I would assume that this is information in possession of HR. And by its nature, that information is confidential. And the salary, it's one of them. That you cannot have access to another person's salary. Even HR, they take oath that they won't disclose information about people's salaries. So a disclosure of that information, or if you are found in possession of that information, of course you have to account how did you get the information.
And in this instance, it was erroneously emailed to her. So it miraculously dropped into her email inbox and she went through it. And then there was an email after that to apologize that it was sent to the wrong person and she should perhaps pretend like she never saw what she saw.
Which is true. Once you are told, it happens in the nature of any business, that you receive a wrong email, and once you are told that that was not meant for you, and it means that you must pretend as if you have never sent it. Unfortunately, that's how things are. You can't use that information which was not meant for you. That constitutes misconduct.
So that's why I said at the beginning of this particular interview that, you know, at the face of it, when you look at the story, it looks like an injustice and it looks simple that she is being targeted. But the law can be humbling, honestly speaking, in this instance, that now when you take us through it, this is potentially classified information or confidential. So what would be the process is if one does discover that they are being paid less for doing the same job as their colleague? What would be the process? Would they go through the promotion of access to information?
You ask for information. In any event, the Act requires every employer, in terms of Section 27, to disclose any differences in terms of salaries. And if you know, or you may know in a number of ways, if that information came in the manner that it did, all what the employee needed to do was to then ask for information. And excuse me, once that information is then given, then the employee will then decide what to do with that information. But employers are required in terms of the Act to address differentiations. It's not easy. It's not an easy thing that you just see the other person earning more than you, and then you come to the conclusion that there is discrimination in terms of remuneration. There could be a number of reasons why another person is earning more than you earn, although you are doing the same job.
Because in most instances, some people reduce it to saying that, well, you didn't negotiate for a higher salary, that's your own problem. Are you saying that that on its own would be unethical on the part of the employer to say if Mfundo cannot negotiate for something higher, then it's her problem? Or they have to say no, it's the same job, same grading, onus is upon them to ensure that they remunerate me fairly, even though I'm a bad negotiator?
Yeah, it can't be based on negotiations. The Act is very clear. It's based on that the work is the same or similar or work of the same value. So Those are the things that you consider when you pay a person a salary. Of course, there would be justifications at why somebody else earns more than another person. And those justifications would be a lack of experience or qualifications that that person has, and the performance, of course. But you can't, on the basis of negotiations, you say, no, you were a bad negotiator. It can't be. It can't be.
So if we look at this case now, from what I'm getting from you, it seems as though the employee that has since been dismissed perhaps got bad legal advice, because she sought legal advice and she was told that we're forging ahead, we're going to challenge the pay disparities with this information that we erroneously received. So you're saying, or at least what I'm getting from you, is that that was bad advice. She should have gone the route of reapplying to access that information and then use it to further her particular agenda.
It sounds like a bad advice, but I'll restrain myself in saying that, because I don't know what is it that she told the lawyers. But of course, like I said, you can't use information that you obtain, which is confidential, and use it for your own benefit.
So meaning the next time we hear in corridors that somebody earns more than me, perhaps I need to keep it to myself. I cannot walk into my boss's office and say, I have heard and I want more.
No, even if you want information. You want information as to the act is there. It says people must earn the same salary. All what you need to do is to say you want to know, because you are doing the same job with another person, whether are you earning the same salary. If you hear it as a rumor, you can't then confront an employer with the rumor as if it's a fact.
No, Mr. July, thank you. No, Mr. July, thank you very much for your insights this morning. That's Labour lawyer Sandile July.